So there are a lot of places that are coming out of lockdown. Some people may feel really anxious about it, and some other people might just be excited to get back to their everyday lives. Either way, now is the perfect time to think about getting some legal matters in order to give you some peace of mind. So today we're going to talk about 5 useful legal documents for coming out of a lockdown. I'm going to make some coffee and then we'll get right back to it. So before we get into the 5 documents themselves, I'm first going to put them into 2 different categories. The first category is living documents, meaning documents that are useful only while you're alive. They're revocable, you can change them at any time, but once you pass away, then they're pretty much no longer valid. Those are, number 1, a durable general power of attorney. Number 2, a healthcare power of attorney, also known as an Advance Medical Directive or a healthcare proxy. Number 3 is a living will. Then in the second category, you have estate documents, which are basically documents that say where your property goes after you pass away. Typically, people don't really look at these documents until someone has passed away, but they are revocable, they are amendable during your lifetime. So you can still change them at any time, but really they're not going to be, as I said, really looked at until after you pass away. Those are your last will and testament, or will for short, and a revocable living trust, or a trust. Something that's common to all 5 of these documents is that they give instructions for the unfortunate circumstance that if something were to happen to you, it's like you're leaving behind a note for someone else to keep things going, either while you're alive to keep on top of finances or legal affairs, or to make healthcare decisions, or if you've passed away, what to do with certain assets that you have or to take care of other matters in your life. So as this pandemic has shown, we really can't decide when something might happen to us or if something happens to us. But the beauty of these documents is that they can help to minimize some of the harm for when an unfortunate circumstance happens. So just as a forewarning, some of the topics that we're going to get into are a little bit difficult to confront because, of course, we're talking about death and at times end-of-life scenarios. So no one really wants to spend time thinking about that kind of stuff. However, if you do have the stomach for it and you can spend just a little bit of time thinking about it, the time that you spend now to make certain decisions can mean way less agony in the future if and when those kinds of things come up. And then once you do make those decisions, you can get back to living the life that you really want to live. Okay, document number 1 is a durable general power of attorney. This document allows you to appoint someone that you trust to help take care of your legal and financial matters in case you can't. This means all kinds of regular activities that you do, like going to the bank, paying your bills, filing your taxes, dealing with childcare, for example. Under this kind of a document, you would be called the principal and you would be selecting an agent. And that agent is the person that is taking care of the things for you if you can't. Keep in mind that even if you're married, there are some things that your spouse can't necessarily do for you unless you've given him or her specific authority. If it requires your signature, typically it requires your signature. So unless you've done something like signed a power of attorney, for example, whoever it is that is requiring your signature may or may not want to talk to your spouse. So having a durable general power of attorney can be a really good idea even in that situation. So as I mentioned, the durable general power of attorney gives authority on a pretty broad scope, like accessing your bank accounts, other forms of property, things like that. So because of that, you want to make sure that the agent that you pick has certain characteristics that are beneficial for that situation. Number 1, you want your agent to be trustworthy. If they are handling any bit of your money, you want to be able to trust them implicitly. Number 2, you want them to be pretty squared away. If this person is a hot mess and is always struggling with all kinds of things in his or her life, they may or may not be able to be there for you in case you are out for a certain period of time. And it's totally possible that someone can be operating under a power of attorney for years even in some cases. So you really want to make sure that that's someone that can actually handle that kind of responsibility for you. Number 3, you want them to be organized. You want this person to be the kind of person that, for example, opens their mail regularly, knows how to operate on a budget, because again, as they're handling potentially your money, potentially your legal rights, you want them to be someone that knows how to handle that kind of stuff. And finally, you want to make sure that your agent is also generally pretty healthy, physically, emotionally, mentally. Of course, we all have our ailments from time to time, and unfortunate things happen to even the best of us. But you want to make sure that this is someone who isn't already dealing with something very chronic that might interfere with their ability to help you in a time of need. And at the same time, you don't want to just pick one agent. You want one initial agent and at least 1 or 2 successor agents. This is just in case something happens to your initial agent that he or she can't act when you need them to. Think of it like a lineup. If you've got one batter that strikes out, you need to have at least 1 or 2 more guys to come up so that you can end up scoring. Someone like Justin Turner, or Cody Bellinger, or Jack Peterson. See where this is going? A beautiful thing about the Durable General Power of Attorney is that it's totally customizable. For example, if you have minor children, you can insert language that appoints a guardian in case something were to happen to you. That way you know exactly who it is that can be taking care of your kids while you can't. And note that while there are some powers in the document that are general and assumed by virtue of creating the document, for example, bank accounts, filing taxes, things like that, there are other powers that you can grant that have to be explicitly stated in the document. For example, if you want to give your agent the power to do real estate transactions for any real property that you own, that can include buying or selling property, or renting or managing that property as well. Other powers include changing beneficiaries on retirement accounts, giving gifts on your behalf, which can be limited either in the amounts that can be given or the recipients that can be given. Again, it's totally customizable. Finally, you can also give your agent the power to create, modify, or terminate a trust on your behalf. We'll get into trusts a little bit later, but for now I want to finish up that Durable General Power of Attorney. And one final thing about document number 1 is that the thing that makes a Durable General Power of Attorney different from other powers of attorney is in fact the word durable. The default for any power of attorney is that if you become incapacitated, that power of attorney loses its power, at least temporarily. So by having language in the document that says just the opposite, that you intend for that document to be continued to be valid even in the time of your incapacity, that makes it durable. Okay, on to document number 2, which is the healthcare power of attorney. The healthcare power of attorney is similar to the Durable General Power of Attorney, but where the Durable General Power of Attorney is for legal and financial matters, the healthcare power of attorney allows you to assign someone that you trust to help with, of course, as you guessed it, health and medical decisions. The healthcare power of attorney is based off of the doctrine of informed consent. The doctrine of informed consent is basically what says that any time you go to your doctor for any kind of a medical procedure or healthcare treatment, the doctor needs to have sufficiently given you enough information to understand what the procedure is about and the risks that are involved, and then you need to be able to give your consent. So before the doctor turns to any kind of document or any other person to give consent on your behalf, they're going to first try to see if you can give consent yourself. So if you're conscious, you are fully capable of understanding all of the information that you need to understand for it, the doctor's going to have a conversation with you. It's only in situations where you're incapacitated that a doctor might turn to something like a healthcare power of attorney, which, by the way, of course, as I mentioned before, is also known as an Advance Medical Directive or a healthcare proxy. Unlike the Durable General Power of Attorney, if you don't have a healthcare power of attorney, There actually exists in most states a framework for doctors to get consent from your next of kin. So for example, if you're married, doctors will likely turn to your spouse next. Or if you're not married, but you have adult children, they'll turn to them next, or maybe your parents or your adult siblings, and so on and so forth. Some states even allow for doctors to look to very close friends as your next of kin. That said, there are some situations where you may or may not want your next of kin to be making certain decisions on your behalf. For example, you might be someone who doesn't have the best relationship with your family. In that case, you may or may not want them to be making those decisions for you. There are also some situations where even if you have a great relationship with your family, maybe your family disagrees on what kind of treatment options you should take. Or if your family agrees, maybe your family disagrees with the medical providers. If the disagreements get to be so bad that they require litigation, this can take a terrible situation into something far, far worse that requires a lot of money and time and emotion that is already a tough place to begin with. So that's why you would want a healthcare power of attorney. It lines up who you want making decisions on your behalf. That also gives you the opportunity to have conversations with that person or those people that are in the lineup about what it is that you would really want. Number two, it can also give some directions on what kinds of treatments you would want or not want in a certain situation. Regarding the healthcare agent, a few things. Number one, just like with the durable general power of attorney agent, you want to set up an initial agent as well as one or two successors. A lot of people like to set up the same person to act as the agent under the durable general power of attorney as they do under the healthcare power of attorney. This is because there's a lot of overlap that can happen between the two roles. And in terms of logistics and administratively, it can just be easier to have the same person act in both roles. That said, if you don't want that because you want to split up the responsibilities between two different people, at a minimum, just make sure that you have two different people that can get along and work together in potentially a stressful situation. Either way, for the healthcare agent, the most important aspects are that you want to make sure that your healthcare agent is someone who understands your values and your morals and what it is that you would want in a healthcare treatment situation. And you want this person to be able to follow the instructions that you set out in your healthcare power of attorney or that you've expressed to your healthcare agent. If they have a different way that they would want to do for themselves, they have to be the kind of person that can set aside their feelings and, like I said, go along with your instructions. And as a final note, most states don't allow you to set up your medical provider as a healthcare agent. So keep that last bit in mind as well. Okay, so this is where we get into a little bit more of a sobering topic, but bear with me because this is a really important thing to discuss. And as soon as you've made the decisions that you need to make for this next document, you can put them behind you and get back to the things that you really want to be doing. Document number 5 is a living will, which is not to be confused with a last will and testament, which is one of the estate documents that I mentioned earlier. I'll get into the will in just a second, but first, a living will is similar to a healthcare power of attorney in that it regards medical decisions and healthcare options. However, it's different from a healthcare power of attorney in a couple important ways. Number one, whereas the healthcare power of attorney's main substance is geared towards setting up a healthcare agent who can make decisions for you, the living will is more about giving specific instructions to that agent, and specifically in certain scenarios. Number two, the living will is only for situations where you are both incapacitated and in an end-of-life situation, specifically 3 different types of end-of-life scenarios. The first end-of-life scenario is a terminal condition. This means that doctors have diagnosed you with a disease and have determined that even with the best care, they won't be able to cure it. The second end-of-life scenario is a persistent vegetative state. A lot of people are familiar with this one. It's where someone is in a coma, and because of the trauma that the person has suffered to his or her brain, doctors have decided that there's no reasonable possibility that they'll be able to come out of the coma. And finally, the third end-of-life scenario that's covered by the living will is an end-stage condition, which basically means that someone has a permanent deteriorating condition, which makes them totally dependent on others for their vital functions. Some estate planning attorneys will merge the healthcare power of attorney document with the living will so that they're all in one. Either way, whether they're separate or together, most important is that the living will has your options broken down into the 3 different end-of-life scenarios, along with the different treatment categories. So for example, you can decide whether you want hydration and feeding tube, chemotherapy, surgeries, antibiotics, kidney dialysis, things like that. And you would be able to determine in each stage whether you would want each different type of treatment, because it may make a difference which one you would find yourself in that you would want different types of treatments. And one final note about the living will, there are some documents out there that are very similar that can fit the same sort of role as a living will. For example, there's a document called 5 Wishes, which allows you to break down into 5 different wishes that you would want in your end-of-life situation. The 5 Wishes also covers topics that are a little bit more spiritual. So if that's something that more suits your needs, and that's something that you might want to consider. And finally, there's also something called a physician orders for life-sustaining treatment, or a medical orders for life-sustaining treatment, POLST or a MOLST. There are some other options out there that are very similar. It just has a slightly different name. But basically what this document is if you go to your doctor and you have a discussion with your doctor about what you would want in an end-of-life scenario, this is a form that they would fill out, or that you would fill out with your doctor. And then that form goes into your medical file and it instructs the medical personnel on the same sort of topics. So if you have a living will, that instructs your healthcare agent, whereas a POLST or a MOLST instructs your medical personnel. So that's the living documents. Now, before we get into the estate documents, I want to do a quick explanation of probate. So generally speaking, the law likes to keep order when it comes to property, especially when it comes to the transfer of property from one person to another. That's why you'll see a chain of title in real estate, for example. Now, when somebody passes away with property in his or her name, the property goes into something of a limbo because it's unclear where that property is supposed to go, who's the rightful owner. So the law likes to have a particular process of determining the distribution of that property. That process is called probate. Some people have a negative opinion about probate. It's generally something that they want to avoid, and there are some good reasons for that. Number 1, it is public. Number 2, it's kind of a slow process. And number 3, it can also be very expensive, especially if you get into situations where the intent of the person who passed away is pretty unclear and people start to fight over the property. However, if an estate does go through probate, it's not necessarily the end of the world. If someone dies without a will, there's something called the laws of intestacy. So basically a court will look at the family members of the decedent, the person who passed away, and go by order of closeness of the family members to determine where the property is supposed to go. For example, if somebody left behind a spouse, usually the spouse is the person that would get the property. If the decedent left behind a spouse and children, sometimes it'll be split between the spouse and the children. Otherwise, the court will look to grandchildren or parents or siblings and onward and outward. There could be some reasons why you wouldn't want to necessarily leave it up to the laws of intestacy, however, and really that is if you have a specific group of people in mind, or a specific person or even organization in mind where you would want your assets to go after you pass away, you would want to have that in a document like a will. So that leads us to document number 4, which is a last will and testament. Contrary to popular belief, a will does not prevent your estate from going through probate. As I mentioned before, probate is for assets that are in your name at the time of your death. So there are pretty much two ways to prevent your property from getting administered through probate. Number one is for financial accounts like bank accounts, retirement accounts, things that are similar to that. You can set up a transfer on death or a payable on death designation, basically setting up certain beneficiaries to take those assets. Number two is to place your assets into a trust. So if you own real property, in particular real property in multiple states, or if your situation is just a little bit more complex than naming one or two or a few beneficiaries on a financial account, then you might want to consider putting your property into a trust. Now, of course, there may be married couples out there that are saying, well, we own our house together, we own it jointly with right of survivorship, so that means that if I pass away, then it automatically passes to my spouse, or vice versa, same thing. Well, that's true, but if only one of you passes away? Let me be blunt, you could both pass away at the same time, or one of you could pass away right after the other, in which case you have your house going through probate. If that's something that you don't really care about, then that's totally fine, but if that's something that you want to prevent, you may want to put it into a trust. But you know what, before we go on about the trust, I still have to talk about the will. As I mentioned, a will doesn't necessarily prevent probate. What a will does is it gives instructions to the court for where you want your assets to go, who you want to be your beneficiaries, as well as your executor or your personal representative. An executor or a personal representative, it's the same thing, just two different names depending on your jurisdiction, is kind of like the agent under your power of attorney documents. It's the person that you trust to go through the process of distributing your estate to the people that you want your property to go to. Now, sometimes the recipient of a gift is called a beneficiary or an heir, so I'll use those terms interchangeably. Now, under a will, you can give gifts in different ways. For example, you can give a specific gift that's either a particular item, like say an automobile, or a specific amount of money. Or you can give a percentage to an heir or a beneficiary, the percentage being a percentage of the rest of your estate. If you want to do both types of gifts, you definitely can. The way that would be done is that the specific beneficiaries would get their gifts carved out first, and then the people that get percentages, the residuary beneficiaries, would get their percentage of the residue, or what's left over afterwards. And just like with the power of attorney documents, setting up your agents and successor agents, it's a good idea to set up not just an executor or personal representative, but also successors as well. Okay, so that's the will. You may have decided at this point that you want to set up a trust in order to prevent probate. If that's the case, you would still need a will, but your will would be a much shortened version. So instead of listing out all of the beneficiaries or heirs that would receive your property in different ways, it would basically just say that all of the property that's in your name at the time of your death, if there is any, is supposed to go into your trust. So basically that turns your will into what's called a pour-over will, because it basically scoops everything up that's left over and puts it into the trust. Okay, so you may be thinking, Alita, you keep talking about this trust. What even is a trust anyway? I don't understand any of it. Well, the most frustrating way that I can explain it is a fiduciary relationship regarding property and charging the person with title to the property with equitable duties to deal with it for another's benefit. Or I can explain it like this. A trust is like an imaginary box. When you create a trust, you create this imaginary box. You determine the dimensions, the size, the color, the shape, what goes into the box, what can come out of the box, how the stuff in the box is treated, and so on and so forth. In the same way, when you create the trust, there's all kinds of language that determines what can be done and what cannot be done with regard to the property in the trust and the trust itself. So right now, let's say that all of the property that you own is in your name. We'll metaphorically put it in your pocket. And as you create this trust, you take property out of your pocket and put it into the box. It's no longer in your name. Therefore, when you pass away, it doesn't need to go through probate. So right now, while it's in your pocket, you basically have three different relationships to your property. Number 1, you are the owner of the property. Number 2, you are the manager of the property because you can determine whatever it is that you want to do with your property. It's yours after all. And then number 3, you're the beneficiary of your property because you own it, so you can benefit from it. So when you put the property from your pocket into that box, you have the same 3 relationships to that property, except they just have slightly different names. As the owner, you become the grantor. As the manager of the property, you become the trustee. You still manage it, you still have all the same control over it as you did when it was in your pocket. It's just a slightly different name. And number 3, well, that's still the same. You're still the beneficiary while you're living. So the thing about a revocable living trust is that it is amendable at any time during your life. You can change it, you can rip it to shreds, you can totally terminate it, you can do whatever you want with it. As I said, it's your box, you created it. Once you pass away, there are 2 main things that happen. Number 1, the trust becomes irrevocable. That means that there's no changing the terms of the trust anymore, except for in some limited circumstances where people would need to go to court in most situations in order to get some sort of a change. Number 2 is the trusteeship changes over from you to your successor trustee. Because one thing that I didn't mention, which I meant to mention earlier, is that when you do set up your trust, you set up yourself as the trustee, and then you set up multiple successor trustees. Because just like with the agents, just like with the executor and personal representative, you want to make sure that you have multiple successors in case something happens to your lineup. So as I mentioned, once you pass away, you're no longer the trustee. It's the successor trustee that comes up and is the acting trustee. And what their job is to administer the trust according to the terms that you've set up in the trust document itself. And what they do is they administer it to the beneficiaries that are the people that you want your property to go to after you've passed away. Okay, so that's the basics of the trust. Now, an important aspect of the revocable living trust is the very last stage, which is funding. Now, you want to make sure that it's properly funded because otherwise, if there's no property in the trust, it doesn't technically fully exist. So what some estate planners will do is at the very end of the document, there will be what's called a schedule of assets. And sometimes estate planners will simply write $10 cash, which basically means that if you have $10 cash on you, it's technically part of the trust. Now, otherwise, you want to make sure that you do the work to transfer your bank accounts over into the trust, as well as any kind of real property that you have. Okay, we made it. That's all 5 documents. Cheers to that. If you made it this far, I really hope that you found this useful. One final note on these documents. Once you have them, you want to make sure that number 1, you keep them in a secure place that's less likely to be damaged by fire or water. At the same time, you also want to make sure that they're totally updated over time. This means maybe reviewing it every 5 years or every time you have a major life event, such as marriage or divorce, or you have kids that are born, etc., etc. So if you'd like to learn more about any of this stuff, let me know in the comments below. And if you're in California or DC and have a particular legal matter having to do with estate planning, let me know and we can see if we can set up a consult. Otherwise, if you'd like to support this channel, go ahead and like this video and hit the subscribe button and the notification bell so that you can find out when more videos like this one, or maybe even better than this one, will come out. And finally, I would super appreciate it if you would share this video with friends and loved ones who might be interested. Because unlike the coronavirus, when it comes to estate planning, sharing is caring. Until next time, cheers!